Welcome to the American Legal Technology Awards Second Genius Panel of 2023. I'm Tom Martin, the founder of LawDroid and co-founder of the American Legal Technology Awards, along with my friends and colleagues, Patrick Pallas and Professor Kat Moon, who will be moderating today's discussion. The American Legal Technology Awards is a grassroots organization dedicated to holding up examples of excellence in creative innovation and technology in the legal industry. The Clio Cloud Conference is returning to Nashville, Tennessee, October 9th through the 10th, and the American Legal Technology Awards Gala will take place right before it on Sunday, October 8th at the Gaylord Opryland Resort. Don't miss it. And if you want to find out more, go to americanlegaltechnology.com. Also, if you know of any person, court, law firm, legal department, or technology that deserves to be recognized, please tell us about them at americanlegaltechnology.com. We will be opening nominations April 1st, so that's right around the corner. Feel free to enter nominations again at americanlegaltechnology.com. Today, we will be discussing the DoNotPay debacle and its impact on access to justice in 2023. Today's panel is inspired by our Access to Justice award category, sponsored by ARAG Legal. Before we get started, I'd like to introduce you to Ann Cosimano, who's General Counsel of ARAG Legal, for a word from our sponsor. Ann.
Excellent. Thank you so much, Tom. I really appreciate it. I am Ann Cosimano. I'm General Counsel of ARAG. We are a leading legal insurance provider. And this year, hard to believe, we are celebrating our 50th anniversary of providing access to justice in the United States. So legal insurance, a lot of people don't understand what it is. It works a lot like the health insurance model. Employees sign up for an ARAG legal plan as a benefit through their employer, and they pay an affordable monthly premium to access a network attorney for covered legal matters. Network attorneys provide the services, and then they submit the claim to ARAG, and it's paid directly by us. A lot of people don't know, in fact, 80% of Fortune 100 companies offer a legal plan to their employees today. So it's becoming something that's more and more prevalent in the US. We're constantly working to offer the most comprehensive legal protection to provide exceptional experiences for members and attorneys. And some of you participating today may have partnered with us in either a tech role or as a member of the ARAG Attorney Network. So thank you for that. We have 200 plus team members and 15,000 plus solo and small law practice attorneys who serve on our network, and they're the heart of our product. Really, it's lends to our success. And we believe technology helps drive the speed and efficiency that we need to connect our consumers with the attorneys that can help them. And it provides people directly then with access to justice. So today's discussion, fascinating discussion, really comes at a critical time when people are really trying to introduce different technologies into the courts, into attorneys' practices, and to consumers who are learning new ways to embrace this technology in pursuit of access to justice, which we really support and makes us proud to be here and a founding supporter of the American Legal Technology Award and title sponsor to the Access to Justice category. So finally, if there are any solo and small law practice attorneys that are listening today and you have an interest in learning more about being a provider on our network, check us out at araglegal.com/attorneys. That's ARAG legal.com/attorneys. Thanks again.
Thank you so much, Ann. And I really, really appreciate ARAG Legal being there from the very beginning to support us in this effort. So thank you. I really appreciate it. And with that, I'll pass the baton to you, Kat, and our wonderful expert panelists. Thank you so much. Take it away.
Thank you, Tom, and thank you, Ann, and thank you, ARAG, for sponsoring this conversation. And I will just briefly introduce myself. So I'm Kat Moon. I teach at Vanderbilt Law School. I'm a lawyer. I've been a lawyer for more than 2 decades now, which is kind of terrifying. And I'm also the Director of Innovation Design, and I spend a lot of time thinking about how we can leverage innovation and technology to help more people get access to the law and to justice. And it's an honor to be part of this conversation today. I think that I've got this huge list of questions that I want to dig into, and we're not going to have time to get to nearly all of them, but we're going to do our best. And we're also going to reserve some time at the end for questions from folks who are joining us. So please pose questions in the Q&A channel if you have any as we're going along, and we will get to them. And so without further ado, I'm going to ask our three amazing panelists to introduce themselves, and we're going to go in alphabetical order by first name. So Jazz, you're first. Please introduce yourself, and then we'll go on.
Honored to be here, and thanks for the introduction and the sponsorship from ROG as well. So my name is Jazz Hampton. I am the co-founder, CEO, and general counsel of TurnSignal. TurnSignal is an app that connects drivers to an attorney on a video conference the moment they're pulled over or when they're in an accident. And the mission and goal is simple, and it's three-pronged. It's to protect drivers' rights, to de-escalate these roadside interactions, and third and most importantly, to get everyone home safely. When I was in law school as a public defender, I was then in corporate law as a civil litigator for a few years. But this is what I left all of that to do because I care so much about what we talk about here today, which is access to justice and everything along those lines. And I know the folks, the friendly faces on this call, as fellow warriors in this work. So thrilled to be here. Thanks.
Thank you. Natalie.
Hi, everyone. Can you hear me okay? Great. I'm Natalie Knowlton. I'm not Kristen Sonde. I'm filling in for her, but prepared to be underwhelmed because she is fantastic, and we wish she could have been here today. I am the founder of Access to Justice Ventures, where we're empowering entrepreneurs building scalable justice solutions. I'm heavily involved in advocacy in states around the country on unauthorized practice of law reform and Rule 5.4 reform. I'm also the regulatory innovation advisor at the Institute for the Advancement of the American Legal System at the University of Denver, where I have spent the better part of the last 2 decades at this point doing research into self-represented litigant issues and family and civil justice matters. And I'm delighted to be here today. Take it away, Sonia.
I am Sonia Ebron, CEO at Courtroom 5. I'm also really delighted to be invited to this important conversation and to see you all again. I am the non-lawyer on the panel. I've learned all the law I know from actually representing myself in court. So Courtroom 5 is an automated legal toolbox, sort of an automated online litigation support tool for people handling more serious civil claims. So folks are handling their home foreclosures, their medical debt collection, civil rights claims, you name it, on Courtroom 5. And so we help them understand the legal elements of what they're dealing with. We help them understand some of the relevant options wherever they are in the case. Then we help them assemble the documents they choose to file to be as persuasive as they can in court. So, I am also one of the board members of the Justice Technology Association. I know Jazz and his organization are one of our members. We've got just a lot of interest in this conversation. So really glad to be here.
Well, thank you and welcome to all three of you. And I do want to say we miss Kristen. Thank you to Natalie for filling in, and we are sorry Kristen's not here. And let's just jump in. So we invited folks to join us for this conversation centered on the DoNotPay debacle. And so I want to clarify initially that our goal is not to dig deeply into what's going on with DoNotPay as much as to use it as a starting off point to really investigate and explore issues that we need to be thinking about and talking about anyway. I think that the DoNotPay situation surfaces these for us in a way that hopefully we can find helpful. I'm going to briefly just hit on the latest of what I know, what's going on with DoNotPay with respect to litigation. So initially there was a petition filed in New York for pre-suit discovery surrounding allegations regarding the services that the platform is or is not providing. In California, there's been a proposed class action, I think initiated by users. And then the most recent is a lawsuit filed in Illinois on behalf of a law firm, I believe, potentially wanting to represent all law firms against DoNotPay, alleging unauthorized practice of law. And I welcome as we go along for anyone to chime in with more nuanced information regarding the allegations against DoNotPay and how those are progressing. And I think most importantly, we can use it again as a jumping off point to talk about the issues being surfaced, right? So there are a lot of them, and I think they're really important. I think they're very important for folks who are deeply committed to scaling access to legal help using technology. I think we can all agree, I will speak only for myself, and I think knowing the three of you and the work you're doing, we can all agree that leveraging technology is critical to this effort, right? This is a key way we are going to help more people, either help themselves or give them help directly to solve their legal problems. So let's just jump in. I first am curious just to hear what you all are seeing, hearing as repercussions, potential or real, based on the issues that are being surfaced in the litigation that is surrounding DoNotPay. And why don't we go in backwards order now? And Sonia, I'll invite you to kick us off.
I think justice tech as a sub industry, if you will, is really too nascent to tell the impact of something like this. Certainly, the conversation we're having is one of the repercussions, right? This issue has been in the news in ways that few of us could put it in the news, could put justice tech in the news, right? And so a lot of people are learning about this sector from the news, of what happened to DoNotPay. We are going to be talking with investors about this, whether we are distinguishing ourselves from DoNotPay or aligning ourselves with DoNotPay. I know that there are some investors who really dig that kind of behavior, if you will, and what happened here. We're going to be talking to press. We may talk to some of our customers, right, who've heard this. And so there's no way for us as an industry to ignore what happened. It does absolutely affect us, and we have to talk about it. We have to flesh it out. We have to figure out what it means for sure. I'll be honest with you. I've spent most of the time since this whole thing developed, trying to ignore it, frankly, right? It can be such a distraction when this sort of thing happens. Given, certainly it's important and we have to talk about it, but I think it's important also not to overplay it. Not to let it define the sector, right? We have a lot going on in justice tech. And I would say, I wouldn't say DoNotPay has indicated they're even thinking of themselves as a part of this sector, right? And so certainly we want to be careful not to associate ourselves too closely with what happened there.
Thank you. Natalie.
Yeah, so for me, this fits into the broader, and it's kind of percolating at an interesting time, but it fits into the broader ways that we're seeing in states across the country to reform rules on the practice of law. So the key issue here from my standpoint in terms of what I'm particularly interested in watching DoNotPay and these events unfold is the unauthorized practice of law and what that potentially means, particularly given the litigation that seems impending and is pending. So when we think about what the ramifications could be from that litigation and from this bigger picture about unauthorized practice of law, that's both exciting and scary from my standpoint. It's exciting because we might have some actual opportunity to put unauthorized practice of law in the spotlight, to talk about what it means, to talk about what it's doing, why it's doing what it's doing, and some of the harmful impacts that we have because of these regulatory rules. But it's also scary because a lot of this, with respect to legal information, has already been regulated. It's already been litigated. And I would really hate to see us go down the hole of how can we increase the scope of regulation when I'm trying to rethink regulation in particular. So I know we're going to talk a bit on the call today about this issue of how to regulate legal technology companies. That really scares me to some extent, and we'll get into that. But so just to sum up for me, it's all about regulatory issues for DoNotPay and what the implications are within the broader landscape of justice tech.
All right, you are foreshadowing. Okay, Jazz, you're on.
Yeah, great points made by you both, and I think I won't belabor them. What I will say is, there's already a lot of barriers to funding in the world right now, as we're speaking about that topic specifically, right? If you are raising money today compared to 2020, it's harder. If you are a Black founder, it's harder. If you are a woman, it's harder. If you are a Black woman, it's hardest, right? We know the barriers that are there. And now there's always going to be a list of questions that you have to overcome, whether it's all of those things I just listed, whether it's your experience in the law, whether it's that you're in legal tech and is that too niche, whether it is can you expand this beyond the law? There's a million questions. And the other one, again, in the news is banking, right? Do people even have the funds to disperse right now? Do they have the ability to do that, or are they trepidatious if you're with a certain institution compared to another one? There's a long list of things that are just questions that you have to be prepared for. And I think this is an example of that. But to that point, you can be prepared, but as it was really well, as you pointed out really well, it's what is my answer to these questions? How are we different? How are we the same? How does that jive with that investor? And if you are aligned with them, will that work for you? It's all about scaling and trying to get bigger, and those investors want to help you do that. You just have to make sure you're aligned with them. And that's kind of what it ultimately comes down to as well.
So many potential threads to pull here. So I'm not really sure where to start. So I'm just going to pick a thread and pull it, and I will rely on the three of you to take us in the direction that resonates most with you. I'm going to start just with the big one, and that really is regulation of who can deliver legal services, right? So I think perhaps, this latest lawsuit in Illinois alleging unauthorized practice of law, to me, is perhaps one of the most interesting elements of what's going forward in terms of how this, again, gives us a jumping off point to talk about this in a bigger way. And I will just make a couple of points. So I am not the expert in this particular area the way Natalie is. So I'm most certainly will defer to her in terms of really having a deep understanding of what's going on where with respect to re-regulating delivery of legal services. But I can tell you a couple of things that are interesting. One, I was recently asked to join I think it's just called a committee. I'm not really sure what we are, but it's a group of lawyers in Tennessee who are looking at how we can make some changes to our rules of professional responsibility in the state of Tennessee. And truly, when I saw this email, you could have knocked me over with a feather, because we are not a progressive state in any way, shape, or form with respect to anything related to innovating anything in law. And I don't mean that in a derogatory way. I'm just making an honest observation. So that's interesting to me. So if it's happening here, I believe that there's stuff bubbling up in almost every jurisdiction. Second interesting thing I just want to point out is that Legal Aid North Carolina is launching an innovation lab in conjunction with law schools in the state of North Carolina. And so what we are seeing is really activity across a lot of different fronts to really leverage technology and think very thoughtfully about how we can do as much as we can within the regulatory systems that exist, at the same time that people are really trying to push some envelopes with respect to making some changes. So there's just a whole lot going on, and I'm curious to hear from you all. where we think things are going in the near term with respect to re-regulation, regulatory reform, whatever label you want to put on it, and specifically with respect to how this is hopefully going to empower justice tech startups, people in your shoes, Sonia and Jazz, who are trying to help more people leveraging technology. Where do we think things are going with respect to regulatory reform? And Natalie, I might ask you to wrap this one up for us. So I'm going to ask Jazz to chime in first.
Yeah, it's a great question, and I do think there's boxes that this falls in, right? Is this a technology that fits really cleanly and well within the lines of the regulations as it sits today? Is this maybe pushing the bounds or in gray areas of the regulations that we are today? And do we need to reform the regulations and change how new technology and access to justice technology will fit? And I think there's, not to, a good lawyer never gives a yes or no answer. This is an ecosystem, and until we are changing regulations, then we're going to be working within what we currently have, or reforming how we view or interpret what we currently have. And so as a technology company that's in that space, I'm excited for that. Only fears that I have around that are what you were alluding to, maybe a little bit in states where it's more conservative. Lawyers have I think of all the professions. I think of CPAs, I think of lawyers, I think of everyone. We are the slow actors to move, ironically, in a lot of technology spaces and in innovation in general. And we are very insular. We like to make law, we like to have a moat around the practice of law for a litany of reasons, good, bad, and indifferent. But what I hope for in these changes, and what I look for as a founder of a technology company that is law-based, is how are we making it so that the end goal of all of this, which is the individuals who need legal assistance, that they're getting the help they need. We all know the statistics around the amount of people who do not get legal help when they need it. And that is a problem. So how are we going to get there while upholding the standards that we have for ourselves and how we're passing along the information in law? I think we can crack a few eggs on the way to do it. And if that means understanding it on a different state by state level, that's fine. I would hope that on a national level, we can have an understanding of how we can open the door more for technology to improve that access to justice gap. But until then, I think we're going to be hitting the guardrails a little bit, with the only fear being that some states or jurisdictions or locations might be making it more stringent rather than less stringent. And this is the same for every single legislative conversation we're having, whether it's the Second Amendment or anything else. Something happens, and then people push to change, and that can push it more insular or to expand, right? And that is even more so true when lawyers are doing it about the law themselves. So I'm anxiously awaiting what's going to come around the corner.
Yeah, I think the fact that we are a self-regulated industry poses some unique challenges, and frankly, I think should raise a lot of questions on behalf of the public. But that's maybe a conversation for another day. Sonia, you occupy a unique space in this conversation because Jazz is a lawyer, and so he's running a platform that might be delivering legal services in some respect, but he's a lawyer. You're not.
Yeah,
So,
it's
thoughts.
We both run corporations, which are not lawyers. And so we're in a similar situation there. Turn Signal, to my knowledge, isn't a law firm, and so isn't protected, in that way. I would, let me just first double back, Kat, to your comments about being surprised by Tennessee's progressive actions around regulations. We here in North Carolina, we're all very excited to see what's happening with legal aid of North Carolina and some other things that will be announced later this year, I think. But you want to understand that reduced regulation is actually a conservative principle. And so we are seeing folks on both sides of the political spectrum look at the regulatory regime in a different way. And I think moving us as an industry forward in that regard. To your point, I think my limited experience with regulators, luckily, has shown me that they are not the most tech savvy folks. And this is true, as you know, in the legal industry. And so one of the things we saw coming right on the heels of our conversation today around DNP is Chat GPT, the OpenAI project, and the explosion, and Tom is very familiar with this, the explosion of work, of AI work in legal tech. I think any justice tech organization, frankly, we're trying to serve consumers, who isn't also exploring those technologies for ways to better serve our customers, frankly, isn't going to last long, isn't going to be in this space very long. And so to directly answer your question, when I think about what the regulatory environment is going to look like with the advent of these technologies, a state bar that's not trying to hire the best data scientists right now, competing with the big law and hiring those data scientists right now, is going to have a really difficult time regulating justice tech corporations and other providers who are using AI in the ways that we contemplate. So I think it's going to be an uphill battle for them. Maybe some oil on the road for us as we skid towards greater innovation.
Natalie, I'm going to pass it to you next, but I want to make one observation really quickly with respect to something you just said, Sonia, and that is suggesting that regulators need to be hiring data scientists, right? So this is actually a big issue with respect to the fact that we are self-regulated industry or profession, whichever word, we're a professional industry, to make everyone happy. It is actually tradition and historical fact that we regulate ourselves with respect to a lot of issues that we do not have adequate understanding and knowledge and expertise in. And that's one of our biggest flaws in it. It may end up being a fatal flaw, frankly, for the current system. And that is that for, I'm sure, a whole host of reasons, we refuse or fail to recognize when we need expertise. And we fail to collaborate well with those who can actually best provide what we need in order to make really good, smart decisions moving forward. So,
let me just
problem. Yes.
Let me just push back there a bit. So there's UPL, and then there is discipline of lawyers. And when you're talking about justice tech, those are two very different issues, right? And so, you've got to, if you're going to go after a justice tech organization or corporation, you've got to make a case, right, in court to get an injunction against operations. And if you don't understand the technology or can't even have a good conversation around the technology at play, it's very difficult to make that case to enjoin a company's operations. So that was the only point I was talking about. But to the extent that we use lawyers as well, as many of us do, yeah, there's a lot of self-regulation that can be done by state bars there. But you still are going to need some data science to try to enjoin a company's operations if they involve AI.
Absolutely. And I think my point was just that issue expands much more broadly than prosecuting unauthorized practice of law. Something we should pay attention to. All right, Natalie, what you got?
All right, and you'll have to excuse me if my internet connection's a little unstable, it seems. So the regulatory reform movement around the country, and this is why I think DoNotPay fits perfectly within this, is that we're seeing a tension, and it's a tension I'm sure all of us feel, and especially those who are working in this industry feel. It's do we work within the current system and work with stakeholders in the current system, or B, do we just kind of barrel through and really push the boundaries of what we're doing? I think a lot of justice tech companies, and rightly so and smartly so, are working within the bounds of where we can be, and working with stakeholders, working with courts, going to atmospheres and states that have regulatory relaxation and experimenting there. DoNotPay seems to be taking a different approach, and it's not one that I necessarily disagree with, and that is just kind of in your face, this is what we're doing. And I don't know if DoNotPay, I can't make a statement as to whether they're practicing law or not, but as I said before, it's been very heavily litigated that they can provide legal information and they can operate within the bounds of current rules on that front. So that's I think the big question that DoNotPay is forcing all of us to think through is what role do we have in terms of balancing out the need to work with stakeholders and work with the existing structures, or the need to just kind of break down those structures. So I think it's a real tension, and it's definitely something I struggle with personally in this work. And I know that obviously a lot of justice tech companies struggle with that too. But we so often err on the side of let's work within the existing structures because we don't want to be sued and we don't want to be in the position that DoNotPay is in. So particularly exciting that we have a venture-backed company with the actual potential, monetary potential to mount a good defense against this. Not barring, I'm not going to comment on any particular harm that has come to consumers as a result of the practice of law if they are found to be doing that. But I think it's just an interesting tension.
And you provide the perfect segue, I think, into what's at the heart of the tension, and that is the consumer, right? And protection of the consumer. So at least on its face, the existing regulatory system for who can deliver legal services, the justification is that it protects the consumer of legal services. Now, we all also know that the vast majority of people who need legal help, we're talking about people law, not corporations, but people who need legal help, do not get legal help. Various statistics and studies you can cite to support that, but let's just say somewhere upwards maybe of 70% of like normal people don't get help with their legal problems from anyone. So we have a system that's failing. And we have folks who control the system who really, on a wide scale basis, haven't been very interested in making any changes to see what might actually lead to more people getting help. So where do we situate the consumer of legal services in this conversation? And how does situating the consumer, if our goal is to help more people get the help they need, either from another person, from a service, to educate them so they can help themselves better, because right now that's your only option. Hire a lawyer. In most jurisdictions, hire a lawyer or help yourself, pro se. Where do we situate the consumer of legal services in this conversation about how we regulate or don't regulate services like DoNotPay, services like yours, Sonia, services like yours, Jazz? Where's the consumer in this conversation?
Such a crucial point, Kat. I just want to raise Kristen Sande again in this conversation. Shortly after the debacle, if you will, developed, Kristen published a short piece in Medium, just asking for and calling out the need for more responsibility to that consumer amongst justice tech organizations and folks who were delivering services to consumers. I think, we're all entrepreneurs. To the extent a mess has been made in our space, that is just the state of play. I mean, we're used to playing hardball. We understand the playing field. Folks make messes, in our business models all the time. My whole position around DoNotPay, frankly, is, hate the game, not the player. It was a great stunt to the extent it was, right? But there is a consumer, to Kristen's point, there is a consumer who could be harmed by this whole debacle to the extent that it cast an unfavorable regulatory or investment or any negative light on the sector as a whole. There are people out here managing their own very, very difficult cases, right? Trying to wade through civil procedure, often opposed by lawyers who obviously have all the advantages in that space. And, they don't need more obstacles, right? We want to be lowering the barriers to them getting the services they need rather than raising them. And so that's, in my mind, where the consumer is, just having a more difficult life as a result of all of this.
Yeah, all this kind of ties back to prior questions, and I'm sure what we're going to talk to moving forward. But I do think, and I hit on this a little bit, that there's like an ecosystem that we all are playing a part in. And in the civil rights movement, they needed a Rosa Parks, they needed a Martin Luther King, and they needed a Malcolm X, who approached it in very different ways. But that entire ecosystem is necessary to create change. And I think we're in a similar place right now. There's going to be the DoNotPays of the world. There's going to be other people who are trying to reform the actual law and all of the things, right, and the regulations. Um, and as I see us going forward in that, I think it's a real opportunity to hopefully do it in a really positive way. And so I couldn't agree more with what Sonia just said as well.
So from my
So
perspective, in terms of, oh, sorry.
Go ahead.
And from my perspective, where the consumer is in terms of regulating the practice of law, where they are in that conversation is very different from where I think they should be in that conversation. Because right now, they're really not in that conversation. It's a reactive type of system. We regulate once harm has been done to consumers, unless it kind of sparks what's happening now with DoNotPay in the larger justice tech conversation. Now we have all these lawyers saying, wait, we need to regulate this. We need to proactively regulate this so that consumers aren't harmed on the back end. But that's not how lawyer regulation works. We let lawyers go out into the world and practice family law, not having had a single course in family law in law school, and not having been tested on it with the bar exam. And they're able to go hang a shingle, and they're really not going to be prosecuted for any consumer harm until it happens. So I get really nervous when we start having these conversations, and this is what DoNotPay has really made me anxious about, is all of this now attention on, okay, how can we regulate companies like DoNotPay, when that's not actually the conversation. If we're going to have that conversation, then I also think we need to have a conversation about how we're regulating attorneys and whether that's transparent. It's not, and it should be. And we need information on consumer harm if we're going to start trying to regulate legal technology companies on that basis as well.
And I'll say, around centering them as well, and I agree with what Natalie is saying. My dad always says you can't let perfection get in the way of progress. And what we know right now is we have a lot of work to do with getting to these folks, the consumers who need the help. And so we have to start taking real tangible steps to get towards that. And there's going to be bumps in the road. But if we don't actually try to do anything, and we're doing the same thing, we shouldn't expect anything but the same results. And so if we're really focusing on that consumer and trying to get to that 70%, which is the statistic I hear all the time as well, then that is what we need to do. We need to start making changes by centering them and getting to them as quickly as possible.
So there are some questions popping up in the Q&A that I think expand on some of the issues we are discussing. So I'm just going to throw one in there. And I actually see, I think Natalie's working on an answer to Chase's question, but I'm going to read it out because I think it's a good one for discussing. So, and then hold on, too many questions popping up. And then did it disappear because you answered it? Natalie.
Oh, wait. No, it should be
his
here.
question. Yeah. No.
It went over to
Answered.
answer.
Okay. I just need to change my, yeah. I just need to change my, no, it's funny.
I can read it out if you
so
want.
there are concerns. I've got it. I found it. Yeah.
Okay.
Thanks, Tom. Are there concerns among this group that the emergence of two class actions in the arena are going to lead to more filings against justice tech companies from firms who do class action work? And I want to point out Chase's use of the word filings from firms. He wasn't referencing consumers, and it's like there's a lot to unpack there. Thoughts? Anyone?
Yeah, the private enforcement action against UPL, I think, is really, really challenging. The whole lawyer monopoly is, of course, everyone who's probably here today finds some aspects of that challenging. But the issue of allowing incumbents in an industry to enforce actions against competitors on the grounds of existing law that doesn't require any consumer harm is just, I'm sorry, it's batshit. So it's really concerning for me.
Sonia, Chaz, any thoughts?
It's it has, since we started, been a concern, right? You just have to lay out all of the risk, to your operation and try to mitigate them. That's the work of entrepreneurship. Frankly, it hasn't risen for us because we've got so many other challenges ahead of that, right? And so we just are, head down and dealing with the same product market fit issues that we always have been. So that the needle hasn't changed for us, but it's in the news. These things are going to be going to make life more difficult. There's just no way around that.
Yeah, and I think perceived or factual, that fear might be based more on folks who are saying, I can replace lawyers and take them out of this equation. A company that is like a core of their thesis is different, and not saying that is the case here, is different than saying, hey, this is a great technology tool that you can leverage to make the practice of law better for you and the consumer. Like, of course we should do that. And what law firm doesn't want to be a part of that? And so from my perspective, if we're offering tools that can help the end consumer, especially those can help the end consumer and the lawyers, like, great. If it can help when it lands on your desk that it's not a mess and it's already compiled well, or maybe that pro se's draft of the brief is not as horrible as typically it is, like, great, that's going to help us. And so that's why I don't have as much of a fear around that, because at least for us personally, because we're building things to enable lawyers to reach more people and for them to do it. Not saying that we shouldn't do things to make it easier for non-lawyers, but specifically for how I'm looking at it from our perspective, it's a win-win. I want drivers to feel better. I want lawyers to be able to connect with them in a real way immediately. I want law enforcement to look at the back of a vehicle and say, oh, this is a turn signal vehicle. This can be the safest interaction I have today, right? If it's a win-win for everyone, it's like, I'll be happy walking into a room arguing about that, but I assume that we won't have to.
So I actually think that the biggest threat to lawyers right now is not technology, and it's not folks like y'all leveraging technology to try to help more people and also help lawyers, as you mentioned, Jazz. Like, it's again a win-win. It's actually the lawyer business model, because the current business model doesn't really encourage lawyers to embrace all this help, because it directly impacts how lawyers typically measure their and deliver their value. So that's just kind of a gravel road, but I think it kind of dovetails into this point. Since we announced this conversation, ChatGPT-4 has come upon the scene, and a lot of people who are much more knowledgeable about how the technology works and who probably were more skeptical of it on the front end than I am, because I'm an eternal optimist about many things, are opining that this really is going to be game changing. There have been some questions in the chat about pro se litigants leveraging AI, these generative AI models like ChatGPT-4, to help themselves. So I think this conversation is going to be forced to shift in some ways, because these things are being let loose upon the world in a way that completely goes outside the bounds of all the structures that we think we have in place. And I will say, I'm of the opinion, this is again just my opinion, I do not represent the American Legal Technology Awards when I say things like this, but it is my opinion that lawyers have created a regulatory system that it just exists for us. Like, we have this system that exists for us, and the rest of the world just kind of goes about its way doing what it needs to do. And I think that the emergence of this technology that is really going to put some power, whether we think that power is accurate or good, or however we want to kind of describe or define that power right now, but it really is going to shift power in a way that we've seen in small ways, incremental ways over the past few decades. But the rate of change and the shift in power over who controls information that's relevant to legal problems is shifting in a way that we have never seen before. So how does that play into where things are going to go? And I think in two different ways. One, how are we going to look at managing all this differently. I don't want to use the word regulating, but managing. And also, how is this potentially going to impact the development of new platforms, new products? Sonia and Jazz, how is this going to inform and empower users of your platforms? I'm fascinated, and also kind of terrified, but what about y'all?
I'll jump in. So Courtroom 5 has always deployed a low level of AI since the very, very early version. Certainly ChatGPT and GPT-4, and its successors is going to really accelerate our roadmap in that area. So we do, foresee being able to serve our customers, our pro se litigant customers, much better in the future using this technology, obviously within the bounds of the law. I won't say much more about it. It's in development. One of the things we do at Courtroom 5 is sort of develop and demonstrate our tech before announcing we're going to do it. And so I guess we're sort of distinguished in that way from the subject of this conversation. But, there's no way that technologies like this are going to make life are not going to make life easier for pro se litigants. I mean, they're already doing it. I would just call out an interesting dynamic with some of the technologies as we've explored it. And Richard Granite has a wonderful blog out about this subject right now. Sometimes you can ask ChatGPT a legal question and get a very fulsome response. And then you can ask the same question a bit later and get essentially a UPL response. Oh, well, I'm not a lawyer. We're not lawyers. We can't, you need to go talk to a lawyer for the answer to that question. And so it's almost like, without any word changes at all, without any difference in the prompt, you can get either a state bar's answer or the technology's answer, right? And it's really interesting. Richard ended his blog by suggesting that maybe lawyers were already threatening OpenAI with UPL enforcement. And so,
No doubt.
the beautiful thing, though, I will just say is that the technology does allow people, companies, organizations to use their own training sets on this technology, right? It doesn't have to go out into the internet. You can have your own knowledge base and use the raw tech to develop your own AI products. And I think that has some huge potential benefits in terms of fact checking or just the sorts of errors, potential consumer harms that are concerning people.
Thank you, Sonia. Jazz, do you have anything you would like to add?
Yeah, I think I don't know what your all's experience was when I was in law school. I was a lawyer for the first time, first college graduate of my family on either side. And so explaining things, I would always say like, oh, I use Westlaw. It's like Google, but for lawyers. And there's this magical wall that prevents any of you from ever seeing it. And then once I saw it, I was like, whoa, like all of this is just here and I can grab it all that barrier prevented people from understanding what cases look like and how to cite to them and how to annotate and how to find better law that applies to your situation more. And if we're removing that barrier, what people pro se litigants looks like is really different if people know that world exists. And what's I think happening in lawyers' minds are ChatGPT or versions of it, or any just language model system. It's giving you access to those kind of documents that you didn't have before. And so now being a pro se litigant is starting to look really different, and you're getting closer to practicing law or whatever we'll call it at that point. And these barriers are going to keep coming down. And so we have to be ahead of it as a regulatory with our regulations, because now that the information is in front of people, the people, that 70% is going to keep trying to use these things on their own. And I think of it from a judge's perspective, sitting there, and they're like, what's going to start coming at them? Do we want them to be on the receiving end of things that are well written and understanding the law and not using outdated cases and all of these things? Can we help set up a system that allows these pro se litigants to do that better? Or are we going to keep making it more messy with people using things that they don't quite understand while trying to navigate this without a lawyer?
So if the legal profession's ostensible reason for maintaining our current regulations, which by the way, are a product of the second industrial revolution, that is a time that ended more than 100 years ago. We are a century away from the time in which we created these regulations, which also were a complete experiment. We didn't know if they were going to work or not. And if we have so many people not getting help, maybe they're not working. But is having a conversation about the regulation the wrong conversation to have? And Natalie, you mentioned earlier in this discussion your concerns about wanting to regulate justice tech companies and what this looks like. And so I'm curious in the last few minutes that we have, and this kind of pulls in some comments and conversations that's been happening in the Q&A. How should we be approaching this? Like truly, again, going back to the consumer, going back to the millions of people in this country who face legal problems on a daily basis and do not get any help. And currently, for most, the option is hire a lawyer or qualify for legal aid. And we also know that maybe 1 in, I think, 22,000 people actually gets help. Qualified people gets help from a legal aid lawyer. So your option is to get that help somehow, or help yourself. And at that point, we truly are hands off because lawyers say, I don't represent you, so I can't give you any legal advice, any legal help. So we are truly hands off. And I've seen some folks who I respect greatly express concern and opinion about how various rapidly advancing AI models could actually lead to greater consumer harm. And so what should lawyers do about that? But is it really any different than what we're doing now? And how do we reconcile these things? Because I'm not willing to let us off the hook if we're the only ones who get to play in this playground. We can't fail this many people. So how do we reconcile these things with a model for helping more people and keeping people safe if that is going to be the job we made? Anyone?
Well, I mean, your last point there, Kat, I would just start if our goal is to really help people, then we need to not be a self-regulating profession because self-interest is always in the mix there. And it's, not throwing lawyers under the bus, it's human, but that means that we really can't put consumers first when we're regulating ourselves. And then I think there's just a bigger conversation that we have to have about regulation and about regulatory objectives. What's our regulatory objective? Is it preventing consumer harm or is it vindicating the harm once it's happened? Our entire legal system is based on an event and then enforcement. And so if we're going to start having conversations about regulating legal tech companies at the front end and requiring that, then we need to have a risk-based regulatory system, and that needs to be applied to lawyers as well. Someone in the audience, and thank you very much, I'm so glad that you brought this up. I love that this DoNotPay conversation is happening at the same time that Tom Girardi revelations are coming up and about this wide-scale corruption of the California State Bar. Do we have the same regulatory system as for attorneys? And this shows the dangers of self-regulation, and it also shows that, hey, maybe we shouldn't be talking about regulating technology companies when we can't get our own house in order. Let's figure out how to better regulate lawyers first. So I think that's a really important conversation that we need to be having. But regulatory objectives, if it's consumer protection, then I would suggest that we need to start completely over and figure out what that means for the law, for lawyers and legal technology companies.
I would just add to that, we also need to fold into the mix the harm of a consumer not getting any help at all, right? Which is what we're looking at now. Most people go into court without any assistance other than Google, what they can find there. And that is certainly for most of them harmful.
Yeah, and I would like to live in a utopian world where we can do some type of regulation and it works really well and it fits really well. But I think what we've learned is lawyers do not understand technology too well. And so them doing it by themselves, it's again, we struggle to regulate ourselves, let alone something that we do not understand. If we were regulating how technology is going to change our profession, like word processing would have been a concern, because now where it used to dictate a summary judgment motion and dictate that, and then hand it to a paralegal who would add the citations, and then hand it to executive assistant who would type it on a typewriter and then bring it to a buy. That was a process that cost money for everyone. And if we were going to regulate that and say, whoa, this is going to cut too many jobs, we're worried about how it's going to be used, we would be in a worse position than we are now. So I'm nervous about us regulating technology when we don't even understand it or understand the capabilities. Because we can put in guardrails right now that do not even address AI, and then AI is going to be right here next year, and then the year after that, it's going to be down here. And so, to the earlier point of hiring people that understand technology, we need to make sure that we have a good grasp on the technology before we even try to regulate it in the first place.
So we have just a couple of minutes left. I have been scrolling through the Q&A, and I also invite the panelists, if you see anything that you specifically would like to respond to, I'm happy to let any one of you kind of take us out with something.
I love Nick's question early on. That was, what do justice tech companies need from the community? Is it angel investment? Is it VC backing? Is it media support? Yeah, if it bleeds, it leads. And that's why, things like DoNotPay are on the front cover of things, because it's like a big story that people will read. But let's talk about all the success in the media about the technology companies and what they're doing. And then beyond that, of course, venture capital and angel investing is a huge part of the work that all of us are doing. If you're going to enter a space willingly, and I always say there's no position more oxymoronic than being the CEO of a startup and general counsel of the startup, right? It's like I'm debating these questions all the time, and to navigate that really confidently, having that financial support to say, we're going to go through and we're going to do this really well, and we're going to address these issues as they come, or we're going to hire someone to address them before they come. That takes a lot of forethought, effort, and time. So I think whether it's angel investing, VCs, or positive media opportunities, those are all really helpful.
Sorry. Yeah. I would just also say that just in terms of looking forward, it is really important for us to have a collective voice in justice tech so that we can provide counter examples for some of this behavior. Justice Tech Association, I'd like to think, is positioning itself to play that role. And so I would invite anybody who is running or is aligned with our mission at Justice Tech Association to come on over and apply.
And that, I think, puts a fine point on this. There's the opportunity for actually the entire legal industry to learn from folks like you, Sonia, you, Jazz, who are doing this very intentionally, very thoughtfully, very well. And you're doing it without the benefit of a very clear system that's telling you exactly what you can or can't do. Instead, you're centering the consumer, the person, the people who you're trying to help. And I think actually lawyers could learn a lot from the way that you all are doing this work so thoughtfully and intentionally. And maybe some of us will be curious and and learn a few things, take some pages from your book. I want to thank you all. It is 1 o'clock my time. We have reached the end of our hour. I want to thank all of you so very much for joining us in this conversation. There are at least 20 questions on my list that we didn't get to, but we knew that going in. We would just kind of see organically where it went. It has been recorded, so it will be available if anyone wants to rewatch, if you missed something, or for others to watch. Tom, I'm going to turn it back over to you now. Thank you all so much.
Well, thank you, Kat, and to all of our speakers. This has been an amazing discussion. We're so blessed to have all of you here today. And also such engagement from the audience. We've gotten so many questions, we couldn't get to all of them. So thank you very much to Natalie, Jazz, Sonia, and Kat for moderating. We're all very appreciative of your time and honored you spent it with us today. And a special thank you to Natalie for jumping in at the last minute to help us with the discussion. And again, a big thank you to Ann Cosimano and our sponsor of this Access to Justice panel, ARAG Legal. Remember, the Clio Cloud Conference is returning to Nashville in October, and the American Legal Technology Awards Gala will take place right before on Sunday, October 8th. Don't miss it. You can learn more at americanlegaltechnology.com. If you know of any person, court, law firm, or technology that deserves to be recognized, please tell us about them at americanlegaltechnology.com. Nominations do open up just around the corner on April 1st, so please let us know about them. And before you go, please hold on. We're going to be back in June with our past winners panel, so watch out for that invitation. And thank you all. Signing off for now, but I'll see you in June and hopefully at the awards gala. Thank you, everyone.